A very warm welcome to everyone, and thank you for joining us for our second session for the day, sponsored by Ellen and Overy. My name is Yue Min, and I practice at Drew Napier in Singapore. I'm also a committee member of the Young MCIA. Today's topic, very interesting topic about managing disputes with states and state parties, the common challenges, lessons learned, and practical solutions. And that's what our speakers for today, very distinguished panel of speakers for today will be sharing with us. I'll just take a few minutes to just introduce our speakers for today. First off, we have Mr. Harish Salve KC, who actually needs not much of introduction. He was formerly the Solicitor General of India and is a senior advocate at the Indian Bar, practicing largely in the Supreme Court of India. His practice encompasses a wide range of matters, including public international law, human rights, civil fraud, and tax. Mr. is admitted to the bar in England and Wales and was appointed King's Counsel in 2020. Next up, we have Mr. Matthew Hodgson, who's based in Hong Kong. Matthew specializes in international arbitration. He has acted as counsel and advocate in more than a dozen investment treaty disputes worldwide under the ICSID and UNCITRAL rules, as well as acted as counsel in ICSID annulment proceedings. Matthew has also been appointed as arbitrator in a variety of matters, including HKIC, ICC, as well as SIAC matters. We have also with us today Ms. Sheila Ahuja. She's my fellow Young MCIA committee member and also co-chair of the committee. Sheila is also co-head of A&O's India group, and her experience spans across most of Asia in a wide variety of jurisdictions. She has rights of audience before the senior courts of England and Wales and the courts of Hong Kong. She's also enrolled in the Bar Council of New Delhi and is also qualified to appear before the Singapore International Commercial Court. Last but not least, we have Mr. Vinod Kumar, partner of JSA. He has extensive experience in handling general civil and commercial litigation matters, arbitration matters, as well as matters involving public law remedies. Vinod represents clients in arbitration disputes arising out of a diverse range of contracts, including franchise agreements, infrastructure projects related to ports and road construction, gas supply contracts, power purchase agreements, as well as EPC contracts. As we can see, we have a range of expertise with us today, with us on the topic of investment arbitration, states, and dealing with state parties. I will not take up more of your time, and I will leave it to the speakers to give you their thoughts and insights on the matter. But I should also mention that the videos and the transcripts of these sessions would be available on the India ADR Week website, www.adrweek.in. Without further ado, enjoy the session for today, and I'll hand it over to the speakers.
Thank you very much, Yuetmin, for that introduction. I'll take over as moderating this session. I've got the fun job of coming up with questions for the topic, which I'll introduce in a moment, and not having to actually answer any of them, but to call on this, I think, very esteemed panel to give us their different insights from their very different perspectives of their practices. Again, this is, I'm not going to reintroduce everyone, so I'm just going to dive straight into the topic, which is managing disputes with states and state parties. And what we'll focus on, and I think step by step, is common challenges, lessons learned, and practical solutions. And what I'm going to do is, we've just done a little bit of thinking of everyone's different backgrounds. I'm just going to direct questions to each of you on the panel and ask you for your views on your perspectives. Feel free to either answer my question or just share what you feel of the different subsets of the topics. So I think first just starting with just setting the stage a little bit, current challenges and trends. So Mr. Salve, if I may, and you should be used to me putting questions to you just on the spot by now. With disputes involving states, right? It doesn't just involve legal idiosyncrasies, but also has political turbulence, economic instability, and public opinion, right? It's a lot more of a vexed sort of platform than what you might call the straightforward commercial disputes. In your vast experience, which if we went through, I think we'd well past the hour that's been allocated to us, can you just tell us what is your perspective on the unique challenges that you've faced in disputes both for and against states?
Yes, thank you, Sheila. Thank you for your kind words. And also, I'm used to you putting me on the spot with questions, so that's all right. If one may take a step back, investment treaties are meant to protect investors from idiosyncrasies. And when we say idiosyncrasies, legal idiosyncrasies are the least of them. Investments are governed by domestic law, and investment treaties allow massive elbow room for domestic policy changes. Invariably, and of course there are marked exceptions, governments behave in a manner incompatible with investors' rights broadly in two situations. One, if there is a political upheaval, and it may be caused by political circumstances, it may be driven by economic circumstances, like those cases where we had massive devaluations of certain currencies, or it's driven by corruption. And we have seen so many of them. The big allegations in the Yukos case all border on corruption. So many other countries we've seen allegations border on corruption. So, and it could be a economic change based on a political whim. And I've seen that in the entire airport privatization was purportedly thrown overboard, and the new government, of course, later on came on with the same. The disastrous treatment of investors in telecom at the 2G phase, where for a rather slim reason, the Supreme Court set aside all the licenses and unilaterally imposed punishments which are not based in any legislation. I mean, if somebody had challenged it in a BIT, I'm sure they would have had an excellent case. So these are the two broad drivers of the kind of aberrant behavior which BITs are meant to protect against. I have, again, leaving aside what we call the outliers, I've very rarely seen an award which has sat in judgment on the political wisdom of a government if the panel is convinced that what has happened is within the bounds of reason and within the bounds of governance.
Thanks, Mr. Salve. Actually, that's it's an interesting perspective that often is difficult to sort of ring fence just the legal issues from what is inevitably sort of a more convoluted, and often actually the dominant factor is not the legal one, I think, as you rightly said. Matthew, you, of course, we have the benefit of Matthew in the form of an A&O in-house investment treaty specialist. What challenges do you think arise from managing disputes with states, with experience of handling international disputes with those states that don't have a similar experience?
Thanks very much, Sheila. I mean, it's quite interesting sort of reflecting on my experience with the firm, actually. I remember when I first became involved on the state side of a dispute, it was 16 years ago, and back then, very few states had seen multiple claims, right, beyond Argentina and the NAFTA countries, which was really where investment treaty claims got started in earnest in the 90s. But most states had seen at most one or two claims, and many had seen none at all. Things have changed a lot, of course, in the intervening 15 years, and you now have a lot of states who have got significant experience of defending themselves in investment treaty disputes, and India is a good example of that. and they will tend to build up an experienced in-house legal team. It's often centralized within the Attorney General's Office or Ministry of Justice, who will take the lead on all matters, all claims against the state. And sometimes they're involved quite actively in preparing the defence. Indeed, some states handle it entirely in-house, but others will participate in fact-finding, etc. So they become quite sophisticated in terms of their processes when a claim is first notified, to put out a tender in due time. They're familiar with the arbitrators in the field, submission procedures, disclosure, etc. But of course, that's not true of all states. So for instance, right now, I'm currently acting for one state facing its first bilateral investment treaty claim. So inevitably, there's something of a learning process for states who just haven't faced these claims before. And in some instances, they don't centralize where they who deals with the claims. It may be dealt with by whichever is the most connected ministry to the facts of the case, which can be challenging because then the state doesn't build up the institutional knowledge of how to deal with these claims. And it can be a practical disadvantage as well. Of course, if a state is slow getting off the mark, they can be in default during the tribunal appointment process. I have previously acted for a state where we arrived and they had a tribunal had been selected before we were instructed. So that's obviously means you start on the back foot. But ultimately, of course, once they do get external counsel involved, it's our job to guide them through that process and to help them to manage their own internal stakeholders so they understand what's coming down the track as well, including things like disclosure, which can come as a surprise. But I think in practical terms, when you're on the other side from a state as an investor who's less experienced, and it brings us to something we may touch on later, but it can, I think, slow down settlement possibilities, because if the state has not got such experience, they may be more reluctant to get into that dialogue, certainly at an early stage.
Thanks, Matthew. And I thought it was very interesting, the comparison between the procedural sophistication of certain states, just by virtue of having done this over and over again, as compared to those who haven't. That said, when you look at states like Brazil and India, who, as a result of lots of experience in investment treaty, have actually changed their investment policies in the context of investment protection treaties. Going forward, do you think that shrinks as a matter of substantive right, the investment protection for foreign investors via states like that?
Yeah, it's a good point. And to that list, you can add, of course, the intra-EU example where now BITs within the EU are not considered valid as a matter of EU law, albeit for a different motivation, that in that case to level the playing field, as it were. But for sure, there has been a pushback against investment treaties, and clearly to that degree, it does reduce the available protections. Although there is some respite for investors, because of course, where there's a unilateral termination, you typically have a sunset clause of 10 to 15 years for existing investments. But to keep this in perspective, it's quite interesting to note, and I looked at the figures before this session, that there have actually been 147 new BITs and MITs concluded in the past 5 years alone. So clearly there is no sort of consensus shift away from investment treaties. I think the more mainstream pushback is actually involves including more, what some people call more balanced treaties, which are slightly less helpful from the investor's perspective than the traditional model BITs. You see that in a lot of the multilateral treaties and indeed the BITs, where they clarify the scopes of protections. They might, for instance, say that fair and equitable treatment means the customary minimum standard. They may have express carve-outs for certain types of public policy-based decisions. So I think that's really the recalibration that I think is more mainstream. And I think what's interesting is that almost all states do at least have some investment treaties remaining, including India, of course. And so what ultimately happens is that those investors who are best advised and are planning ahead can still get the protections they want. It just requires a bit more effort for them to do that by way of upfront structuring. And one of the other interesting trends that I've noticed in the past few years is that whereas historically it was the oil and gas and mining companies who were very aware of investment treaty rights and would structure their investments to gain protection, because they were historically some of the most easy targets for states looking to raise revenues. We've now seen many more clients, for instance, in the telecom space and technology space, doing the same because they feel similarly exposed to political interference. And that's an interesting, more recent shift.
Thanks, Matthew. And just, I guess, keeping to the topic before we move on of current challenges and trends, and Vinod, I guess, focusing on your India-focused practice.
Have you, Sheila, sorry to interrupt. I don't know whether you know what happened in India about the new model treaty. This was on the heels of Vodafone, where there was still a lot of gung-ho about how dare an international tribunal question Parliament. Some people who raised the question didn't realize that international treaties are above municipal law. But then knowledge of law is not particularly a strength of those who are in government. So they suggested treaties which were running out. They suggested a slew of treaties, including to the United Kingdom. They proposed a treaty and they just dropped the arbitration clause, and they had a committee set up. And one of the people on the committee said informally they want your advice. What can be done? And I told them, I said, a treaty without an arbitration clause is nothing more than a solemn promise. You might as well not have the treaty because it's meaningless. If by domestic law you change the rules of the game and you don't have a treaty, you have zero protection unless you have an international arbitration. So I believe none of the countries to whom the new treaty model arbitration was proposed by India have agreed to sign.
Yeah,
That's
and
very interesting. Sorry to jump in there. I mean, one of the things I often think is forgotten in the debate about future of investment treaties is that the two most important standards of substantive protection, fair and equitable treatment, or something very similar, the customary minimum standard of treatment, and non-expropriation without proper compensation. Those are principles of customary international law, which in theory apply across the board anyway. What is not in existence across the board is a system of enforcement for those rights. So as a lawyer, it's a sort of it's a difficult idea to accept that you have supposedly substantive rights of international law, but no means to enforce them. And I take Mr. Salve's point that the idea of having an investment treaty that specifically seeks to underline some of those rights and potentially add others, but then offers no enforcement, seems to be quite an unattractive proposition. And I expect that's why it didn't find acceptance.
And given, just to follow on from that, and to anyone, to Mr. Salve or anyone, given India's, I guess, increasing position of, being one of projected to be one of the four largest economies by 2050, what do you think India will do? Do you think it has to pivot back in terms of rebalancing the benefits and the avenues that it gives its investors to align itself with where the rest of the world, or a large part of the rest of the world, is?
My feeling is that this is not, you have to, as they say, watch the space. The reason is there is a tension between 2 points of view. One is a sense of perhaps, maybe to a small extent, even misplaced enthusiasm that in the next coming decade, India seems to be the country investors would like to bet on. Seeing potential growth, increase in infrastructure, et cetera, and India opening up more. And India has done some very good things on other parts. The other is having finally come to terms with Vodafone. The saga of Vodafone has finally come to an end with Parliament accepting the international award and reversing the prospective effect given to the legislation. Is there an acceptance that after all, investment treaty arbitration is not that bad? To that, there is a ongoing dispute with Antrix Devas, which continues. And there is a very strange judgment of the Supreme Court of India which now is playing out in the Singapore court in one of the BIT award challenges. It's also, I believe, been subject of the next BIT arbitration by the same person, by the investors in entry. So there again, there is a feeling that this gets into areas where the government would like more elbow room. So there is this tension in India. So I think the only thing you can say for India is watch the space.
And actually, just hanging on to that point about the tension in India and judgments coming out of India, and particularly in the settlement that happened when the Vodafone judgment was, or award was trying to be enforced around the world, actually. Vinod, I wanted to come to you on your experience of what you think the risks are that parties face on the ground here when there are enforcement issues or, the enforcement proceedings on foot via judgments and awards that involve states, either way, for or against a state entity.
Thanks, Sheila. So, a common remark which you will hear from any litigator in India is that the real difficulty of the litigant starts after the judgment is passed or the award is passed by the tribunal. Because, and that statement, I'm sure, applies equally to other jurisdictions as well, because enforcement is a challenge. And it's kind of a universal problem. And now, while we are talking about situations where state is the counterparty, but even if it is not, if you look at the whole, the way in which enforcement works, whether it is of foreign judgments or of international commercial arbitration awards, foreign awards, talking from an India perspective, while we are a signatory to the New York Convention and you can have it enforced, but if it is a BIT, then you have your own challenges. And to add to the confusion, we have had conflicting judgments of the high courts. One high court saying that a BIT award can be enforced in terms of the New York Convention, that is Part 2 of the Act, and the Delhi High Court saying that, in two judgments saying that you cannot do it because they have their own reasons, saying that it is traceable to public international law and actually it's not a commercial contract. So and if you look at the whole aspect of enforcement of international commercial arbitration awards, the whole process of seeking an enforcement under Part 2, and although it is identical to the New York Convention Article 3 and 5, what it basically does is you have to re-argue. It's a retrial, basically, and of course we have seen instances where the state is on the if it is on the other side, you've had strange arguments regarding state immunity, which is essentially a public activity defense, being dragged into commercial disputes. And those things happen, and therefore, from a non-state entity point of view, when it comes to arbitration, and when you're against a state entity, you are against an entity which obviously has the resources. It can continue to agitate the issue in the in the domestic forum till the highest court possible, the enforcement action, I'm saying. And therefore, time and cost is a huge challenge. And again, talking about India, if you look at the time, and this is relevant because almost, if you look at the data, almost 50% of the cases in India which are there in courts, the government is a party to. Now, what does it show? It clearly shows a tendency to litigate on the side of the government. Therefore, there is a huge challenge, and especially concerning BITs because of the conflicting judgments.
Thanks. And I guess, on the one hand, one would say that jurisprudence here in India develops quicker than anywhere else just because of that, because, there's no stone left unturned. And India is just seeing so much more activity in the courts on these issues than other places. I want to move on to or pivot to a sort of related topic, which is whilst, in Mr. Salve's words, while we're waiting and seeing, what India does, and drawing on the experience, Matthew, that you shared of say, some other states, I guess to Mr. Salve first, what lessons are we learning? So in the context of forum choices, right, and just looking at the way things are now, what are perceived advantages and disadvantages that really matter in pursuing disputes that are state related when you compare it to international tribunals or arbitral tribunals and the national courts? And of course, you, Mr. Salve, have been at the helm of all the sort of big cases that are, subject of a lot of discussion. Well, what do you take away from that? And what can you tell us are the pros and cons of one versus the other?
See, the real problem about selecting fora and selecting remedies, I'm sorry, I have to hark back to the previous question. Enforceability. A foreign investor who is starting any legal proceeding is looking at something which would not be a piece of paper in his hand at the end of a long and expensive process. Let me give you two examples. The problem of enforcing in public international law, that is on a slightly different subject, the cases which we used successfully against Pakistan, the Avena and the other cases, where the ICJ said that you must have a review and reconsideration of a judgment of final conviction by a state court in the US. The follow-up is very important. Went to the state court, and the state court said there is no provision in the law by which we can review and reconsider. And the order of the International Court of Justice is in public international law. It doesn't help us. With that, America then was in breach of its international obligations. So the President of America issued an order, because international policy in the federal system is with the President of the US. He issued a presidential directive to the court to review and reconsider their judgment in the light of the ICJ judgment. That was challenged in the US Supreme Court, and the US Supreme Court said executive interference in judicial functions is not allowed, and this crossed the federal state barrier and struck it down. Now, if at that level, a judgment cannot be enforced, this is the tension between judgments which ultimately where the international court finds fault or where international tribunal finds fault with legislation. Let's take Vodafone. Vodafone was easy because the tax was not paid. So if Vodafone walked away with non-payment of tax, it was fine. Take the reverse case, Kane, where the tax was paid. If the government of India had dug its heels in, it's all right for international enforcement. And the problems of enforcing against state properties, you have all sorts of claims of immunity. I was appearing in a case which, of course, got put on hold because the award was set aside for the UCOS enforcement in India. And the first defense was the government of India stepped in and said, sorry, we will not allow you to enforce this against Russia. So the problem against enforcement is real. Now, if Kane Energy had come to India and said, we have this award, and we have this award, the tax department would have said, sorry, but we are acting under Indian legislation. And they would have said, but we are acting under an award. And a municipal court would have said, I cannot act under public international law. I can only act under private law. And that's municipal law. And therefore, I have to uphold the demand anyway. Now, until these issues are resolved and a mechanism for enforcement is created, and I see a massive problem looming. Theoretically, suppose the Anthrax round 2 BIT goes up and an international tribunal says that the way in which the creditor has been allowed to wind up the company which has an award, or the downstream company on the basis of which the award has been made, doesn't measure up to the FET. What happens? You have a Supreme Court judgment which upholds the winding up, and you have an international tribunal saying this doesn't measure up. What happens? And there is, I can't think of any answers in which, if they are again awarded a monetary, I mean, it's all right, you want to go and attach a property of the government of India in the United States or somewhere else. Increasingly, India's public sector is not doing international business. Most public sector companies today have become listed entities, so their assets would not be available for enforcement. This is a major area in which, if I was on the other side negotiating an investment treaty with India, I would not only ask for an arbitration clause, but I would ask for domestic protection by way of legislation, by which awards can be enforced. And I think the international community has to come together. I mean, it's very unsatisfactory. You know, I appeared for Vodafone in India in a suit filed against the second arbitration which Vodafone had invoked, because Vodafone first went under the Netherlands Treaty. There was a jurisdictional objection taken. We were a little unsure about the word. So the other British, the upstream British entity, started one under the UK-India Treaty, which did not have this little carve-out which the Netherlands Treaty has. And the government of India argued abuse. The tribunal said, we don't find any abuse. They challenged it by way of a suit in India. And the suit was dismissed by the judge. But he held that he could not go into abuse, etc. He upheld jurisdiction. And that's an interesting judgment. Now, and what he did not squarely address, although I raised it, and which brings the huge issue. If a dispute under public international law, the Republic of India includes the judiciary. So it's like a defendant saying, I restrain you from carrying on proceedings against me. Now, these are all the conceptual cobwebs of the interplay between public international law and private law and municipal law. And unless these are resolved, there is a very major problem in enforcing. And I don't think any investor is really happy with the idea that I can go and search globally for some asset somewhere, especially for big countries like India, because people don't want today other big countries. It's different for other countries, but a big country like India, with whom today everybody wants good relations, they won't encourage picking up an Indian asset, and the British government may come and oppose it and say, sorry, I will not allow you to enforce this against India. This is a major problem which has to be resolved.
That's really well, I think, sort of contextualized, isn't it? And I want to just pick up on the point you made about the investor's perspective and how the last thing that they'd want is for, their lawyers to be running around the world trying to give some meaning to, what you rightly described as that paper decision for the time being. Of course, in the meantime, what an investor would want to think about and always have on the table, actually, whether it's a commercial or a treaty dispute, is settlement. And how do I get, cut my losses? And especially if you have a favorable award, or even in the process of trying to get one, if it's clear that the investor has a strong cause of action, are there ways to avoid this entire remit of complex issues by trying to settle with the state? And Matthew, I just want to ask you for your experience around settlement discussions with states. Is there a particular point in time at which this is more suitable? A lot of people sort of say the best time to do it is to settle on the award. So you go through the entire proceeding, get the award, and that's your best bet in terms of leverage with the state. But even then, do we ever see a situation where the state's willing to come to the table? Matthew?
Well, settling with the state is never easy, of course, because officials are reluctant to put their name to a settlement which may later be criticised, either because it was overly generous or, worst case, there can be allegations of impropriety. So given the average investment treaty case takes over 4 years, it's often very tempting to put off the decision in the hope that it might be someone else's problem. And in a worst case scenario, you can always blame the international tribunal. So it's difficult to settle with states. There's no two ways about it. I think it's always easiest if an investor can create an acceptable structure that doesn't involve payment by the state, so they don't have to write a check, particularly if they're doing ongoing business in the territory. So, for instance, in one case I handled for an investor, it was resolved by the state extending a telecoms license. In another, they corrected a property title register in favour of our client, but they didn't have to sign a check, and politically that was important. Now that said, I think, and it sort of goes back to the earlier discussion we had as well about states becoming more sophisticated in the process. I have seen in recent years states settling some disputes which perhaps 10 years ago they wouldn't have done. There's a couple of examples of that. I mean, one, of course, Sheila, in the public domain was the case you and I did for Nissan against India, where it's in the public domain that it was settled after a jurisdictional hearing following substantial payments. But settlement's never going to be quick. I've not seen any of these cases settle at a very early stage. Typically, it's been a year or two in. And I think partly that's because states won't settle until they feel they've been properly advised on the merits of the dispute and the likely quantum for understandable reasons. They want to know what the risks are. And typically they only feel they know that once the statement of claim and accompanying evidence has been filed, which is some way into the process. It doesn't mean, of course, that an investor can't make clear at an earlier stage that they're open to discussion and try to build the right contacts to make that happen, and to avoid unnecessarily aggressive action in the arbitration, which can make settlement more difficult. And they need to use commercial, diplomatic, as well as legal leverage to do that. I've even seen investors use PR firms to try counter the negative press that they've had locally, which might make a settlement more difficult, effectively trying to create the political space for a settlement to be done. One interesting example I had, which settled last year, was claims against a Southeast Asian state and SOE. It related to a failed oil and gas project. And there we actually had parallel commercial and treaty claim going. And in the end, it settled for a payment of $800 million by the state, which is one of the largest known payments by a state in relation to the settlement agreements. But it came after 2.5 years of negotiations, and the legal process was one part of that, but only one part. There was a strong commercial push on the ground. There were good relationships on the ground. The legal process was used in conjunction with that, and we would escalate when we felt the government were delaying, which of course governments will have a tendency to delay in this process, even if they think they're ultimately liable. We would use an escalation, whether it's filing a trigger letter, starting claims, or sort of pushing the legal process along to kind of make sure they realized that we weren't going to just negotiate indefinitely. So that was another success story, and I do think there's more room for it in recent years than perhaps historically was the case. But you're right, Sheila, and coming back to the enforcement point, I've also seen several treaty cases settle after the award, where effectively the investor takes a haircut to avoid the hassle of enforcement. And the investor has a couple of options at that point. They can try sell the award. There are third parties who will buy awards, but for a very significant haircut, in my experience, often sort of 80% plus, to buy the award, or they try to enforce. If you have an ICSID dispute, you do have an extra option which can be effective, which is using the leverage of the World Bank to create pressure. So in a couple of cases where we've had states not pay, we have written to the Secretary General of ICSID, copying the President of the World Bank, noting the default, and often that has been enough to procure settlement. In fact, in one case, simply threatening to send that letter to the World Bank was enough to bring about the settlement, because developing states typically don't want to get on the wrong side of the World Bank. But of course, that's only if you've got an ICSID state, and of course, India is not one of those.
Thanks, Matthew. What was interesting, your description about the different functions, and sometimes the legal function is pursuing the claim while the commercial function is trying to settle the matter, and it all happens simultaneously. I guess one possibility, I don't know whether it's hypothetical or real, but one possibility of merging this is a mediation type situation where even the lawyers have to come into the room with the commercial guys and, be told by somebody, get rid of this. And Vinod, I guess to you, do you think that options like this, alternatives to writing out the full process like mediation, have any utility where disputes with states are concerned?
So I totally agree with Matthew when he says that settling with the state is extremely difficult. But I firmly believe that mediation has utility. In fact, tremendous utility. I mean, I don't think there'll be two words if you were to ask anybody on, how has arbitration as it is, has it been successful? The whole enforcement process takes time. Therefore, I'm sure invariably you will get an answer that no. So you need to have alternates. And I have some data. There was a survey conducted by the Singapore International Dispute Resolution Academy sometime just before the pandemic in 2019. And the question was, are you satisfied with the outcome of enforcing arbitration awards in investment treaty arbitrations? 27% said no. A similar survey was done in London by the Queen Mary College. And the question was, in investment treaty arbitration disputes, would you want introduction of mandatory mediation? 64% said yes. Now, if we, I'm sure if you conduct a similar survey in India, I'm sure you're going to get a similar response, if not a better one. And if you look at it from the other side, that is from the state side. Now, this is from a report by the Standing Committee on External Affairs regarding India and bilateral investment treaty, and this report is of September 2021. Where a specific recommendation has been made that in investment disputes, there has to be pre-arbitration conciliation or negotiation to arrive at a settlement. Now, we have seen the tendency of the courts. The Supreme Court has been pro-mediation, including the recent judgment where, under the Commercial Courts Act, they've said that it's mandatory pre-institution mediation, and even the earlier judgments. Therefore, if you look at the whole thing, all the stakeholders, whether it is the parties who are contesting or whether it's the court, they want mediation. Now, I totally agree with Matthew that yes, mediation may not work. You may have wasted your time, but then what we need to do is we need to have time-bound mediations. Even if one case is resolved by mediation, I would think that's a huge success, because it's any day better than being, like Mr. Salve said, getting a paper, in your hand and trying to figure out how to enforce it, going to which jurisdiction. So, when you compare it with that, why not have a mediation? And if it works, it works. If it doesn't, then you go for your, your regular course of action, which is arbitration.
Can I be the bad boy here and say anybody who thinks that in a really controversial decision, the government is going to agree to a mediation in a sensible way is not aware of ground realities. Let's be very clear. Commercial arbitration entirely to private people, no question about it. All investment treaties have compulsory pre-arbitration mediation. So that's a given. In some cases where there is a genuine difference, it might get resolved at that stage. In the kind of cases which we have seen, especially with countries like India, the reason why they end up in a deadlock, which then results in a bilateral investment treaty arbitration, is nobody on the government side is willing to do the right thing. Now, you may not be willing to do the right thing because of reasons of corruption. You may not be willing to do the right thing for reasons of public opinion and a mass hysteria created over a particular project or a particular person. And the other layer in countries like India is which civil servant would like to sign off on a controversial decision. I have seen some very bad settlements in India. On the one hand, the double thing was settled, and you know the controversy which started 3 years ago, and that controversy was called for. On the other hand, we still have in the Supreme Court of India a petition by the government of India to reopen the Bhopal settlement. So if somebody asks me in India, should I settle with the government of India? I tell him, I wish you best of luck. In an ongoing case, I won't want to name them. It's a commercial arbitration between the government and the Director General of Hydrocarbon for a simple 2-page application arriving at consent terms for an interim order pending an ongoing arbitration, the submissions in which are concluded, and the final award has been reserved. It has been going backward and forward for the last 4 months. And I don't see anything happening. And I have a £100 wager with the CEO of the company saying the day you sign this, I give you £100. So in countries like this, wherever there is a controversy, especially involving the kind of figures which we see in BIT arbitrations, I don't see any civil servant signing off. Yes, in a different country, in a different system, many times, and this is the only thing I have seen, and I've seen this in one case in India, where the government, for wrong reasons, wanted to settle it, but they wanted to do it under the cover of a mediation. So they got a mediator who rubber-stamped a figure which parties had, for reasons good, bad, or indifferent, agreed to, and then signed off. Having said that, and going back a little, I think investors should also understand that BIT arbitrations are pretty much asking for the moon at times. I know of one case, which I was appearing at one stage. I know in the pre-arbitration stage, there were some offers made, which were spurned by the investor. It went to a hearing, a very eminent tribunal. It was heard, and I believe what I read in GR, that the tribunal has thrown out the investment claim on jurisdiction. Now, there you are. So even investors, but commercial investors are sensible and they would accept any decent offer. Having said that, I am still extremely skeptical on how much negotiations can achieve, where situations have got to the stage where there is a BIT arbitration. And let's be clear of hard realities. An investor, especially in regulated regimes like India, doesn't want to take on the government of India because there are 500 other ways in which they can needle you. So you want to be on the right side of everybody, and you don't want to be seen, especially a foreign investor doesn't want to be seen as the new East India Company, as they are promptly called in India. So if it gets to a BIT, you obviously tried talking to everybody whom you can. Your embassies have got involved. They also try and help. All that is all over. Nobody starts a BIT unless you have your back to the wall. So I don't know how far mediation, compulsory mediation, I mean, which is already there in the treaties, you have people talking to each other. Beyond that, I don't think it's going to serve much purpose.
Sheila, just to respond to what Mr. Salve says, I totally agree with what he's saying, that it is impossible. You can't expect a civil servant to be signing. But where I come from is, of course, BITs is a different ballgame altogether. The regular arbitration where you have a government on the other side, you can have. But even in case of BIT arbitrations, you have a failed mediation. Let's assume you have a mediation which has failed. You have an award. Now, at that stage, if there is a settlement which is being discussed, the history of the mediation will help you in accelerating the whole settlement. I mean, that could be one way of looking at it. So I'm a strong believer that mediation is definitely worthwhile trying, given the challenges in the usual course.
Thanks. And there were a few interesting points there, right? The first is there may be a process which you either voluntarily or mandatorily have to undergo, but then when it comes to the accountability stage of actually signing on the dotted line, what assurance can we give our clients, for instance, that that is going to happen? Or rather, do we say the opposite, that you can go through this, but it's unlikely that somebody will sign this? What I thought was interesting also was, Mr. Salve, your comment about no one is willing to do the right thing. So even the concept of trying to get rid of this rather than public funds fighting it out, and the considerations that one has to balance are often put to one side when things do get to that BIT level. And you have a cooling off period which is meant to be catered to discussions like that. But once the matter becomes public, then the accountability issue gets even more heightened, right, one way or another. But I want to pick up on one thing that you said, Mr. Salve, and ask you to comment, which is that example you gave on an anonymous basis about a procedural, I guess, a consent order on an issue where it's gone back and forth and no one is signing it. That represents to me a wider issue, which you see a lot in state-related disputes, called guerrilla tactics. And often, and we can call them just tactics or procedural rights, versus if you're on the other side of the line, guerrilla tactics. And you often see things like that are designed to do nothing but disrupt the dispute resolution process rather than to pursue one's own sort of procedural legal rights, depending on which side of the balance you're on. Putting a different hat as arbitrator, if you are sitting on the decision-making side of this, what can you do to kind of get rid of this stuff, to make sure that the procedure, or do your best to ensure that the procedure can be as robust as, say, commercial disputes are? I'm not saying those are without their problems, but at least that these tactics can be kind of subdued or brought under control. Is there anything that a tribunal in that capacity can do?
Well, my experience is, as we speak in 2022, and I would have said something very different 4 years ago, I think a robust approach against the government is what is called for. Since the case is settled, I can say this. I was sitting in a room appearing for a foreign investor against India, and an eminent silk, who I won't name, was appearing for India and asked for more time. And when asked by the tribunal why he needs 12 weeks to respond, where 6 weeks should be enough, he said, I appear for a very poor country. So I felt like telling him which country you're talking about, not my motherland. That's not a very poor country. I don't know who your client is. So, and fortunately, the tribunal didn't agree. They gave him 6 weeks and everything got done in 6 weeks. So tribunals have to be robust. Yes, there was a time. And this is a very sad story of what used to happen. And I see it happening much lesser now. In one of the ongoing arbitration, which is still ongoing, it is of some vintage, considering the notice of arbitration was given in 2012. We finally reached the final hearing in December 2022. The tribunal made an order for discovery, and which is something which we were discussing earlier, and production of documents. And the government's reply was, these are government files, we don't produce them. The tribunal said, you're talking nonsense, a commercial dispute. You're claiming that the contractor did not inform you. Contractor says, we have given you full information. When you produce your files, you'll know whether you had the information or didn't have the information. They said, no, those are private files, are private notings, we don't produce. Because that's their mindset, the civil service mindset. My notings are for me. The tribunal, of course, directed production. They challenged it in the Delhi High Court. One of our finest commercial judges, Shakhtar, asked the Attorney General who opened the case, and then Mr. Ganguly, he said, tell me under which provision of the act are you appealing this? He pointed to the section and he says, where does this allow an appeal against an order against production? And he passed a 5-page judgment dismissing it. They carried an appeal to the Supreme Court. And for 2 years, the case was pending in the Supreme Court, during which the arbitration stayed. Now, fortunately, we don't see things like that happening now. But yes, there have been problems where sometimes the judges feel that it's an uneven battle because the government of India is not as well represented. You have a far more powerful commercial team on the other side. But those days have gone. I see today judges tell the government of India, if you sign arbitration agreements, stick by them or don't sign arbitrations. Don't behave in this ridiculous fashion. So yes, things have changed, and I think arbitrators should be robust and should deal with the government as they. We do realize that the government is a bureaucratic machinery. So if you need to file a reply in a commercial organization, get it done in 3 weeks. This may require 6 weeks because there'll be tiers in which approvals have to be granted. But having accommodated the government a little bit for that, I don't think any further quarters should be given.
Thank you. And I'm just mindful of the time, and there's also a question from the audience that I wanted to put to this panel. But just following on from this topic, and Mr. Salve, your views, Matthew, I just wanted to ask you, from the perspective of if you've got commercial routes and treaty routes via a state, what as a party should you take into account as factors of which one to pursue, whether in tandem, sequentially, or just pick one over the other? Well, what should one think about in that situation?
Thanks, Sheila. Well, it's a situation that arises really quite often, in fact, that you have a potential contract claim, particularly where there's an SOE on the other side, but you also have a potential treaty case as well. For instance, because the reason the SOE has breached the contract is it was directed to do so by the government. So it's quite common, in fact, for there to be both options for the investor. And it's one of the most important strategic decisions that they make is which forum to pursue the claim in. Typically, they choose one or the other, obviously for cost reasons, to avoid duplicating the process and to avoid allegations about potential abuse of process or attempted double recovery. The relevant factors, I mean, of course, one of the main ones is always the merits of the contract claim versus the merits of the treaty claim. There may be some similarities, but of course the causes of action are very much distinct. Procedural issues, generally speaking, treaty cases take longer. As I mentioned earlier, the average treaty case lasts over 4 years. There are also the enforcement issues. It goes back to Mr. Salve's point earlier. Really, perhaps the most important factor is you're starting backwards, working out where am I most likely actually to get paid in the end, rather than just being left with the piece of paper. And when it comes to enforcement, particularly if ICSID is available, that often pushes towards a treaty claim because it's got a robust enforcement mechanism under the treaty, the ICSID Convention, as well as the soft power of the World Bank, which I mentioned. That said, I mean, I think overall, and of course, each case is very much on its facts, but I would say other things being equal, most investors who've got both options available would prefer a contractual dispute on the basis that it tends to be more predictable because the treaty standards, of course, have notoriously been applied in slightly different ways by different tribunals, and it's also quicker and perhaps even less expensive. Just to complete the point, Sheila, you mentioned in which case might you pursue both. Very rarely, I have done this once myself, is to pursue both a commercial and treaty claim in tandem. It could be because, for instance, they cover slightly different losses. There may be slightly broader losses you could recover under a treaty claim. They may be somewhat distinct, and particularly if there's a very large amount at stake and both claims have different strengths and weaknesses. So for instance, in one case I was involved in, we knew that in the commercial claim, a defense we might face somewhere in the proceedings was that the state-owned company was simply following a binding instruction from the minister, which as a matter of the governing law of the contract, which was local law, they had to follow. And on that basis, this amounted to force majeure. We wouldn't know if that was the defense until partway through the proceedings, and we didn't want to sit on our hands till then. So what we did was start a treaty claim in parallel, albeit slightly behind the commercial claims, with a view to suspending the treaty claim if that defense wasn't run and advancing it if the defense was run, because of course the state couldn't rely on the minister's instruction as a force majeure event.
interesting. And actually, I've got a question on your reference to the ICSID convention to come back to, but just before I do that, and again, I am mindful, but Vinod, as I guess as briefly as you can, and you actually touched upon this in the mediation context, just more widely speaking, so not confined to mediation, but just from a more commercial risk management perspective, what would you say that parties should keep in mind when negotiating these commercial relationships with states to avoid the situation of the escalation of disputes and then, all the complexities that we discussed?
Now, like Mr. Salve was saying earlier, the most ideal thing for you to negotiate would be a domestic protection by way of a legislation. I mean, but that doesn't really answer the question, because what we are looking for is how do you avoid escalation of disputes. Now, irrespective of what clause you are able to negotiate, I mean, there has to be a willing government. I mean, that's the most fundamental thing. And if the government's behavior doesn't change and they are not committed to resolving the dispute, then your clauses are not really going to help. But yeah, ideally, if you have a government who's willing to look at it, I would probably, the best thing one can probably look for is an evaluative mediation. You have an expert coming and assessing both the claims and trying to tell the parties the strengths and weaknesses of each of the parties, and then even probably proposing a terms of settlement. So that I would think should work.
And thank you, Vinod. And just the final point, and I might ask Matthew and Mr. Salve to comment on this, given that you both mentioned it in the context of India and otherwise, is the ICSID convention. It's actually a question from an attendee, is from the perspective of enforcement and ways in which this could improve, going forward, to Vinod's sort of point just now, would it help, do you think, if India did become a party to the ICSID convention? From enforcement, or even just more generally, actually? Matthew, shall I ask you and then Mr. Salve to comment?
Sure. Well, I mean, ultimately, of course, it'll be a question of how the Indian courts sort of interpreted the enabling legislation for the ICSID convention. But in principle, and just answering it generally, as I've mentioned already, the ICSID convention is more robust in terms of enforcement than the New York Convention. The reason is that the only way to challenge an ICSID award is through the limited ICSID annulment process. So that is on the grounds set out in Article 52 of the ICSID Convention, which are very limited. They don't include, for instance, breach of public policy, unlike the New York Convention. And as to jurisdiction, they are limited. It's limited to where a tribunal has manifestly exceeded its powers. So it's not a de novo review, which you will typically have in the courts on an enforcement challenge or a set-aside challenge. It's got to be higher than that. As to the court's obligation under the ICSID Convention, under Article 54, the national courts are simply supposed to enforce the pecuniary award from an ICSID tribunal as if it's an award of their own courts. So no further review is supposed to take place. That doesn't mean that it's never happened in practice in various states, including, for instance, Argentina over the years. That will ultimately always be within the power of the domestic courts. But what the ICSID Convention tells us is they shouldn't do that. There should be no further review.
Thanks. Mr. Salve, any thoughts to add to that?
Well, from the investor's point of view, ICSID convention is, to borrow P.G. Vodas's phrase, a consummation eminently to be wished. But I do not see India ever signing the ICSID convention. In 1991, when India needed foreign investment, India refused to sign the ICSID convention because the political overtones of the government of India accepting an arbitration of a Washington-based body is simply unacceptable. I know the importance of the fact that I know with what pressure the government of India agreed to initiate proceedings in the Yadav case in ICJ, because there is a strong view in India that any bilateral issue should not be made multilateral. And joining ICSID is opening yourself up to the multilateralism. Am I saying India shouldn't sign exit? No. What I'm saying is, I don't see that happening in India. And
Yes.
much lesser now. If it didn't happen 20 years ago, it's certainly not going to happen now.
Sheila, I just had one point on that question. Now, even if India joins exit, I mean, we are back to enforcing it like a Indian court decree before the Indian courts. So then there's what happens in when you're before the Indian court. So going back to what Mr. Salve was saying, what you need is a separate legislation dealing with enforcement of international awards and treaty awards.
Right. So if there's any prospect, even though it would cut against the current trend, I guess, of the model BIT and the, that sort of direction of India, if it did sign up to exit, you need the framework to protect investors of the consequences of it. Thank you. That's really, look, I'm sorry we've overrun on the session, but hopefully everyone will agree with me that it was a very worthwhile overrun. But thank you all very much for your input. I'm very grateful to the panel for these insights, and in particular for your various different angles at which we came at these topics. I guess the only thing left for me to do, besides thanking, of course, the MCIA as well, is to wish everyone a good rest of the day and week. Bye-bye.
Bye.
Thank you. Bye-bye.
Thank you. Bye.